Okay. Next application, please.
Next application is
Meredith Joyce.
Joyce.
Five.
No, Joyce.
Five.
Thomas and Meredith Joyce, 765 Hill Street. Sorry.
Good evening, board members. My name is John Bennett, and Steve Bedford is here with me this evening from Lewis Berger Group. Mr. Bedford has appeared before you on numerous occasions. He's going to provide an analysis of the architecture and historic, what we feel is the lack of historic significance of the existing structures. I do want to note that, remind the board, three people have spoken in support of this request. A member of the planning board, Mr. McFarland, Mr. McLaughlin, who owns the real estate store, and Michael Broad, who lives in the area. Also, Andrea Marsan submitted a letter in support. So you always tell us to meet with the neighbors and see what their point of view is. We've done that. I want to make sure that that those are part of the record. This is primarily an application which would benefit from Mr. Bedford's analysis, so I'll ask Mr. Bedford to come up and reintroduce himself to you.
Thank you.
Just as a point of reference, this was before us 2 years ago.
Yes, it was before us a couple of years ago, and I had a conversation with counsel who suggested to me that there would be no impediment procedurally to essentially asking the board to look at the application. The board did not have the benefit of the applicant's historic consultant.
Okay.
Okay.
Thank you.
Okay, thank you. Attorney Bennett asked me to review all the files. I reviewed the New York State Office of Parks, Recreation, and Historic Preservation survey forms, as well as the opinion letter of Mr. Studenroth from November 2014, and the Architectural Review Board's decision to deny the applicant's request for a certificate of appropriateness. The designation of these buildings as a contributing resource in the Southampton Village Historic District and the decision to deny seem to hinge on the findings of the 1977 through 79 survey. I believe, as I said before, that at this point the survey is a flawed document. In this case, the survey reports do not offer any reasons for listing each building, and the entry, in this case, the entry on the historical and architectural significance simply describes the building. No reason is offered for its significance, and clearly the documents were not intended to be used as determinants of importance. Additionally, the 1988 National Register nomination, on which much of this is based, identifies the buildings as contributing to the significance of the historic district. Yet the nature of these two buildings does not match the primary and sole area of significance as described in the nomination. That criterion is for its large and distinguished concentration of domestic architecture which reflects the community's early settlement, the area's gradual agrarian growth during the 18th and 19th century, and its rapid development as a fashionable upper-income retreat at the turn of the century. The period of significance goes from 1660 to 1930. Now, since its designation, 759 Hill Street, which is the one that looks like a garage, was a garage, and before that was a plumbing shop, has undergone changes that have affected the building's exterior, including the removal of key elements cited in the survey. The western wing, character-defining feature, has been removed. All of the window sash has been replaced since designation. The large single-light windows on the facade, key distinguishing elements that signal to passersby that the structure of the commercial building, were replaced by new multi-light sash windows. New doors with different proportions have replaced those that were on the building when surveyed. New multi-light windows and new doors on the west elevation are also incompatible alterations. The wall cladding on the western elevation has also been changed from clapboards to vertical siding. Although integrity is not specifically spelled out in local law, without in building integrity of materials and design, a historic designation is without meaning. Since this building had so few details initially, any change in the building fabric is noticeable and should be cause for elimination from the historic district. The building at 765 Hill Street is an unremarkable vernacular store with large store front windows, which, according to the former tenant, Ralph Stark, and owner William Platt, are replacements, as are the porch posts. This was the result of a car driving through it in 1970. The rear of the building appears to be in poor condition, with spaces between the vertical siding and clapboards through the walls. It is a simple, undistinguished structure. Both buildings rely on their setting and feeling to provide a lens, a context through which one can understand and judge the importance of a building, particularly such simple buildings as those under construction. Consequently, context is a very important element in determining a building like this historical importance. The streetscape, the context of the area, is now a hodgepodge of modern houses and small commercial buildings, such as a one-story real estate office. With so little original context, 765 and 759 are spatially lost in the sea of modern homes. As two of the first buildings encountered in the district, is this the initial image of a historic district that the town wants to put forward? In my opinion, their loss would have no significant impact on the character of the historic district.
Does everyone have a copy of Mr. Bedford's letter?
It was in the file.
I don't have a copy other than what's in the file.
Does anyone have any questions for Mr. Bedford?
I don't have any questions. I'm sure Zach does.
Oh, I'm sure he does.
Well, I would benefit from having a copy of
Oh,
Mr. Bedford's statement. And so,
Yeah, no, December 2000,
oh,
November 4th, yeah.
yeah.
so, I mean, perhaps this conversation is going to continue longer than this evening. Give me a chance to read this, but I just want to comment on a couple things. It may be true, maybe a true characterization of the Village of Southampton Historic District, which after all is only one of four.
Right.
But if we're referring to the primary largest historic district, it may be true to say that the greatest proportion of contributing buildings within that district are residential. But I can't help but believe that structures such as the one we're sitting in, and such as the structure on the opposite corner where people tend to congregate Sunday mornings, since they are not residential in nature, that they don't contribute to the character of the district. My only point being that there are many exceptions in terms of the types of buildings and structures which contribute to the overall character of the Village of Southampton Historic District. And my conclusion on page 2 of the brief report that I submitted on November 15th, 2014, and the adoption was, I believe, 1986, to be correct. I said residential, commercial, civic, and religious buildings are included, as are structures, as distinct from buildings. Structures, i.e. the World War I and II memorials, those are structures, and historic sites, Monument Square, the old Southampton and North End burying grounds, which the town of Southampton owns. These are all contributing resources in the historic district. So to simply say or conclude that the predominant type of building in the district is residential should not imply that those buildings which are not residential do not in some way contribute to the district, and that was implied. So I'm going to have to look through this a little more carefully, but I think we have a much more diverse and rich historic district than the great houses that sit south of Hill Street.
True, but we have to look
Okay.
at
You
integrity.
can't pick it up on the
I'm simply picking up
sitting
on-
down, so you have to stand for it.
And so I'm simply saying that the character of this district, when we look at the buildings that were identified in the survey that was done in predominantly in 1979. You know, those buildings were chosen for a reason. They displayed a variety, they had architectural integrity, they dated from various eras, et cetera, et cetera. Whatever the rationale was for defining those boundary lines at that time, none of us was there to know what that discussion was. But it is what it is. And so, this board has the authority to oversee the preservation of those designated and identified historic resources. We don't say, well, this one is more historic than that one. This one's older than that one, so this one's more important than that.
Well,
Those distinctions are not made, and therefore, I would simply submit that two quasi-commercial buildings of the late 19th century, simply because they're not great architect-designed houses, doesn't mean they contribute less. I think that's just the wrong conclusion.
but
But-
if you're going to discuss integrity, then we have an
Okay.
entirely different kettle of fish here.
I agree entirely,
That
yes.
regardless of my opinion about the historic district, and it
Yeah,
still
integrity
is,
an entirely separate.
well, integrity is a key question here.
Okay.
That if you have a facade of a store who seems to date from the 1970s, not from the 19th century, at least according to the prior
Okay.
owner, and you have a facade of a simple garage building that has lost its windows, its main doors,
I think that's
its western side, its siding.
Yeah.
What do we have left there?
Okay.
We have a roof line.
All right, so I think that should be looked at, but
And regardless of the issue of your purview, I think the key issue is integrity.
it's an issue.
I believe it's the key issue.
Okay.
Integrity, design, workmanship, et cetera, is always,
Curtis, let's not get into a debate at this
I-
stage.
Okay. Substantive information, so what you're saying, just so I know and understand,
Right.
I think everyone, you're saying that the original design and the original integrity of the structure has been so altered that it no longer is a contributing structure within the historic district.
yeah, it has been sufficiently altered to
Okay.
particularly.
I'm sorry, I had to dummy it up. for
Oh,
you.
no, no,
Okay.
because we're arguing, not
Understood.
quite Neil's on it.
Any other public comment about the application? Step forward.
Just briefly, Richard S. Vernon, 320 Hampton Road, Southampton. The board knows I represent James and Tara McCahill. The McCahills are contract vendees of the property. It's a conditional contract. And just for the record, we state again that we join in the application.
Okay. Any other comments?
Good evening, board members. I'm Sally Spanberg. I live at 68 Moses Lane. I'm submitting to you a report that has a little bit more information than you've had previously. Originally the property of Joel Rayner, it eventually passed to his daughter Sarah Rayner. After her marriage to Hervey L. White in 1862, the buildings at 765 and 759 Hill Street were built in the late 1800s for her hardworking, enterprising sons, Sidney H. White and Elbert J. White, respectively. They are situated among other commercial properties located along Hill Street, many of which survive. As Hill Street functioned for over 200 years as the primary thoroughfare through central Southampton, it is only natural that both commercial enterprises as well as residences were situated along such a heavily trafficked route. The same is the case for other sections of this main thoroughfare in other parts of Southampton town, such as Hampton Bays, East Quad, Eastport, and Bridgehampton. I'm including in the report examples in Southampton on Hill Street specifically of other historic commercial buildings. The Sidney H. White store at 765 Hill Street was built in the late 1800s on property owned by his mother. The building appears to have been built between 1873 and 1894 and was expanded to the rear between 1894 and 1902. The building remains in its original location and is exemplary of other stores of its period, both in Southampton Village, in New York State, and across America. The Albert J. White Garage at 759 Hill Street was built between 1902 and 1916 on property previously owned at the time by his siblings and previously by his mother. This building also remains in its original location and is exemplary of other stores of its period, both in Southampton, in New York, and across America. I've included in the report several structures similar to both structures subject in this application that are remarkably similar. The subject structures have been altered and changed over the years, first with the approval of this board, and second without rendering them unrecognizable in any way. All work has been cosmetic and has not irreversibly lowered their level of integrity. Also included in this report are maps of Hill Street in 1902 and 1916 showing other commercial buildings scattered amongst this residential community circled in red. The subject property was acquired by Joel Rayner before 1850 and by Hervey L. White in 1866. Joel Rayner was the sixth generation of Thurston Rayner, the first of the name in Southampton, a magistrate and a leading man in the early Southampton settlement. Joel made his living as a boatman and fisherman, indicating that the original use of the older store at 765 may likely have been related to his livelihood. Joel Rayner returned to Manorville, where he was born, by 1865, leaving the property to his daughter Sarah Jane Rayner. Sarah married Hervey L. White in 1862 and had her first child in 1863. She and Hervey had 4 other children. Hervey was a 7th generation descendant of John White, first of the name in Southampton. He made his living on Hill Street as a farmer before leaving for California in 1878 and trying his hand at mining. He never returned. Sarah left her 2 oldest sons, Sidney and Albert, to family members on the North Fork and removed with her 2 youngest children to New York City, where she found work. She soon met her second husband and spent the rest of her life as his wife, dying in Milford, Connecticut in 1896. After reaching adulthood elsewhere, Sidney, Albert, and one of her daughters, Edith, all returned to the property at Hill Street that they had inherited from their parents. They married and raised families there, each built and managed commercial enterprises on or near the property. Sidney ran a carpenter store. Albert had a grocery store and automobile garage. And Edith's husband also had a general store adjacent to the east at 749 Hill Street, which is no longer existing. The White siblings all died by 1930, leaving the property to their heirs, and in 1955 it passed out of the family ownership, but left the buildings as physical survivors of their endeavors from which others would benefit to this day. Also in the report, in addition to several maps, is an analysis of eligibility of these structures for local landmarking and national and state register listing. And last, the purpose of this report is to provide you with more information about the property than previously known. Upon reviewing this information, I hope you may find reasons with which to deny the subject application. I hope you will at least adjourn to consider it more carefully. The claim that the 1977-79 survey is flawed, a flawed document, is true, yet in my personal experience I have yet to come across a survey of historic resources that was not flawed. The fact is that although the survey was purportedly performed by those without considerable training, and while they made factual errors, overlooked properties that should have been included, and included properties that shouldn't have been included, the result of the survey was in the eventual establishment of this village's historic districts. The value of that cannot be quantified, for surely today, without it, this village would have far fewer historic structures. Some people believe that only buildings that are beautiful aesthetically are worthy of preservation. The body of this document hopefully will demonstrate that to be false. Further, replacing these structures with contemporary residences, even if beautiful aesthetically, will not have a positive effect on the historic character of the village as a whole. On the contrary, good stewardship of these structures through maintenance, restoration, rehabilitation, and improvement would create jobs, help to stimulate the local economy, increase the value of the property, and heighten the community's appreciation and attachment to its whole cultural heritage.
Thank you. Any more public comment? Okay, Zach has to analyze the information that's been presented to him this evening.
And this report
And
has been
this,
submitted.
and the
Very
report that was
interesting.
submitted as well. To come back at our next meeting with more information, or at least a response to the information that's been
Yes,
provided.
and we'll have a rebuttal to the salaries report as well.
So you're asking this board to adjourn?
Yep.
Anything from the board before we proceed? Motion to approve applicant's request to adjourn.
I make a motion that we approve the applicant Thomas and Meredith Joyce request to adjourn to our next meeting.
Is there a second?
The second?
I'll second the
yes.
motion.
Second, there we go.
Aye.
All in favor?
Aye.
Next application, please.
The Jack Chrysler on Herrick Road.
For the applicant, John Bennett, you're gonna all receive a copy.
Price is right here.
We're all gonna receive a copy of my letter with exhibits.
Price is right here.
I'd like you all to have a copy of it before we go through it.
Is that other than what was in the file?
Yes.
Okay, so we're seeing it for the first time, is what,
Well, you're seeing it for the first time, but there's no change in any of the architectural details. This is,
no, but it's not what was in the
no,
file.
I haven't seen that yet.
Right,
Jack.
okay.
No.
Thank you.
Also,
Do you want this? Do you want this? Yes, you do.
3 letters of support, which I will read into the record, because I think they're very important. One is from Harold Grant, 75 Herrick Road. Dear members of the board, I own and live at 75 Herrick Road, Southampton. I write to give my, and by the way, you always ask us to see what the neighbors think about this. You try to go to the neighbors and see what they feel about the applications, and we've done that. So, Mr. Grant writes, I own and live at 75 Herrick Road, Southampton. I write to give my full support to the applicants Jack and Anna Chrysler for an addition to their home at 88 Herrick Road. I have reviewed the proposed architectural plans and find them quite pleasing. Which, by the way, just not parenthetically, but most important, the board members all have stated unequivocally in the last meeting that they have no issues with the architecture.
No, I did not say that,
That's
John.
exactly what you said. You
No,
all said that.
Thank you for telling me
You
what I
all said
said.
that. Well, that's what you said.
Okay.
Okay.
For the record, I say that I did not say that. Okay. Thank you.
Well, the record will speak for itself, so I'll go on.
Thank you.
Not only the plans and the character of the neighborhood, but the plans are also sympathetic to the existing house. Like myself, the Chryslers are one of the few year-round residents of Herrick Road. Their house, the changes that they have made, and the manner in which they have kept their property has always been a great asset to the neighborhood. I enjoy having them as neighbors. My understanding is that a comment has been made regarding their plan to move the front of the house closer to Herrick Road, but yet in a conforming location. I have no objection whatsoever to this or any other part of the Chrysler's proposal. That's Mr. Grant's letter. Vito Cab, also a resident at 41 Herrick Road. Dear Chairman Highsmith and members of the board, I'm a principal of Herrick Holdings, owner of 41 Herrick Road. My wife Patricia and I have reviewed the Chrysler's plans for construction of an addition on their residence. We have no objection to the application pending before your board. In fact, we support the efforts made by the Chryslers to construct an addition on their home in a manner that is consistent with the character of the neighborhood. We specifically have no objection to the relocation of the house closer to Herrick Road. And then from Tim Davis, who writes as the principal of 7 James Street. As you know, that's on the corner of James and Herrick, 2 houses down. I submit this letter in support of the, and by Mr. Grant is right across the street. I submit this letter in support of the application of Jack Chrysler. I have reviewed the proposed architectural plans. I appreciate the efforts made by the Chryslers to design an addition that is sympathetic to the existing home. I understand that concerns have been raised with respect to the relocation of the existing home to a conforming location closer to the street. I believe the Chrysler home will be in character with the neighborhood, and I do not have any objection to the proposal before the board. So that's,
Are there the 3 letters here, just for reference? Do any of these neighbors have any financial interest in the property?
no,
Not a broker, not a real estate
Nope.
agent?
no. I will represent that as an officer of the court and member of the bar. Absolutely not. I would have had to disclose that to you in any event.
That's right.
So what you have before you is a letter, because, and the record will speak for itself, but the board was polled and everyone, and again, I understand that you disagree with that, Mr. Broadleaf. I asked you to
Thank you.
review the
Thank
video
you.
of the last meeting, but the board, the way I heard it, unequivocally stated that it was in favor of the proposed architecture. Having done so, under the regulatory scheme in the Village of Southampton, the limitations of the Village Code, the strictures imposed by the New York State Village Law 7-725A, the relevant case law, and this board's own decision, the board has finished its job, and the approval should be immediately granted. Any attempt to limit the applicant's proposal to reposition the house closer to the street, but in a nevertheless conforming setback, is beyond the powers of this board, and thus ultra vires. This is not me saying so. There is enormous authority. Take a look, if you would, and it's important because you are charged with applying the law, and it's important, I guess, that we educate you a bit about the law. Section 7-725A, which is Exhibit B. This is this New York State Village Law, and what this law deals with is site plan review. And site plan review is a term of art. Most importantly, site plan review, you will see at 7-725A2A, allows the board that has the jurisdiction for site plan review to deal with the location and dimensions of buildings. Okay? That's important because this is a statutory scheme that the New York State Legislature constructed enabling a village. It limits the powers of the village, and then it limits the powers that the village has to further delegate those powers. The Village Board of Trustees may, as part of their local law, authorize the planning board or some other agency to review site plans. It must specifically, the village trustees, the mayor and the board of trustees must specifically create that jurisdiction. The Board of Trustees of the Village of Southampton, and that is to deal with the location and dimension of buildings. The Board of Trustees of the Village of Southampton has created that jurisdiction in the planning board alone. And there are only 2 instances where the planning board, which again is the only board with the power to change location and dimensions of otherwise conforming buildings, there are only 2 instances when the planning board, the village trustees gave the planning board the authority to deal with a single-family residence, and that is, 1, for the construction of a tennis court, pertinent to and accessory to a single-family residence, and 2, dealing with certain methods of improvements of flag lots. That's it. That's the only place the village trustees have given that authority. But not only does the state law limit the authority to change the location and dimensions of buildings to a planning board, so does the case law, and so does your own decisions. So the Ferrara case, and I know certain people don't like that case, but it is what it is, and it stands for what it stands for. The court held this board does not have the authority to deal with site plans. Remember, that's a term of art. It says the proposed house conforms to the zoning code. Size, setbacks, these are all bulk zoning regulations. The Supreme Court reversed this board and noted that the board had no such power, and a similar result would recur if this board were to continue to attempt to require the applicant to move the proposed location of the house. I want you all to understand that you are well past any authority that you have, and there are consequences from that, both from a liability point of view and from a sanctions point of view. A similar result would occur. I talked to you about Section 725. In the Farrell building case, and I have annexed a copy of that decision, this board itself acknowledged that it had no site plan review authority. And that was in a historic district, so people talk about, and this board did it correctly and rightly so. because they acknowledged that you had no site plan review. Then, in subsequent cases, for example, before this board, the matter of Robert Alexander and Chris Burnside, the board, in response to a vociferous and continual opposition from a neighbor, that neighbor actually was here tonight, saying the same things, telling you had certain powers which you don't have. That person is not a lawyer. I recommend that the person obtain a knowledgeable local zoning lawyer instead of criticizing this board and this board's counsel. The matter of Robert Alexander and Chris Burnside, this board recognized that it did not have site plan power and did not have the power to change something that otherwise complied with zoning. So whether we're talking about mass, size, location, or setback, these items are all part of bulk regulations. There's one mention of the word setback in the historic sections of the code. This is not a specific grant of site plan review. The reference generally refers to this board's ability to explore undulation and variance of facades where the building, a contributing structure, is at a minimum setback, and then take into account other design features such as raised decks in relation to the location of setback of neighboring structures. It doesn't allow you site plan review authority. So for example, tonight, oftentimes people will come to me and it'll be a contributing structure, and again, this is not a contributing structure, and say, let's try to work with the board so that you pull some of this structure back in a way that it doesn't overcome the contributing structure. Again, this is not a contributing structure. And again, most of the time that I've seen that done, I've always seen it done for the sake of comity, C-O-M-I-T-Y. No one has ever challenged your ability to do it, and no one knows how that will come out. So, again, I usually don't ask board members to read legal memoranda. I think it's important that you do, because I want everyone to know that you have been charged with what the limitations of the law are. Even assuming for the purposes of argument that there is some sort of jurisdiction, the board hasn't demonstrated that requiring the applicant to place the house south of an allowable front yard setback is at all related to the board's powers, or appropriate, or sustainable, given the facts and circumstances herein. It's very important to see, and I credit Mr. Studenroth, because it's very important to see what he first said about this application. Well, we cannot read the minds, and I want to remind you, this is a very relatively, it's not a deep lot, unlike these vaunted 3 houses to the east, which again are just 3 houses. We cannot read the minds of people who built the houses. It is true this is not a contributing resource. And Mr. Studenroth later changed his mind, and I'd like to know why, but I put that in my letter. I don't want to bore the board with that. But it is not, and Mr. Studenroth changed, part of the reason he put a memo that was, I can only characterize as a flip-flop, part of the reason he changed his mind in the memo, he acknowledged was that he thought the Chrysler House was a contributing structure. It is not a contributing structure. So let me again go back to what Mr. Studenroth said and what I think was his first take on this and the only intelligent take. It's true we look for harmonious groupings of houses, but I think there's another way to look at this. Not every single house has to have an identical setback unless there are identical houses and they appear not to have that. So I don't think we can look to historical precedents to say this should or should not be moved from where it is, because it very well could have been built closer to the street to begin with, whatever purposes. The builder had to make more movement in the back to do whatever they wanted to do, which is exactly what happened here. This is not a very deep lot. And I don't think the siding of the house is an important aspect of its architectural significance. That's the only intelligent conclusion here. That's the only sustainable conclusion here, and there's essentially no authority to the contrary. Mr. Bedford was kind enough to give you that in an email, which is also part of the record. Again, as was conceded by Mr. Studenroth after questioning by me at the last hearing, this is not a contributing structure. There is no simply, and then again we went and demonstrated, even assuming argumento, that you had some sort of jurisdiction. There is no uniform setback or sense of place or perception of uniform setback on Herrick that would be violated by this proposal. We also demonstrated that the street is very heavily treed, and that there are a lot of, almost invariably, there is significant screening in the front of the buildings. Mr. Studenroth's answer to that was that, well, bushes and trees can be cut down. Well, actually, that's not the case. Under Village Code Section 65-4, trees or plantings in the historic district cannot be removed without your approval. So,
That's
you
correct.
have to live and die by that stuff. You can't say, in response to the fact that I demonstrated unequivocally that you don't have any sense of place because of the significant screening along the street of any uniform setback. And I also demonstrated by surveys, the only evidence in the record that there is no uniform setback up and down Herrick. But you can't say in response, well, those trees could be cut down, because they couldn't be without your approval. I think
They
it's,
shouldn't be without our approval. Not that it
No.
doesn't happen.
Well-
Well, it's not supposed to be without our approval, but not that that doesn't happen.
You-
John, just play devil's advocate. There's some front
oh, by the way,
alterations.
I'm sorry.
I'm sorry. The front alterations being done to the structure, and although the whether the board feels the architectural or the aesthetics of the design are in keeping in its current setback, and moving it forward, when you say that any increase in whether it be a second story or dormer has a new impact,
No.
and therefore moving forward, well, it does. It would. Any type of increase that you do, whether it be a dormer or a second story, would actually have more of an impact. So, although you may say that that we don't have site plan review, in fact, what we do have is impact, and that means that now the dormer, it being closer to the road, would not be in conformity to because it's creating a more massive structure, and therefore causes concern about the with regards to the aesthetics.
Take a look at the plan. I don't think that can
I'm,
be borne out.
I'm
because-
I'm making where the where the issues. You made a comment about us having the ability to move the structure forward.
Well, if I wanted to
Playing
be-
devil's advocate, if that were true, we still have a responsibility as a board to look at impact in terms of the aesthetics, that which you are changing.
Yeah.
And in which case there may be some issue now in the current setback, it may be it wouldn't be a concern. But now that you're pushing that forward, whatever addition you're doing to the front may have more of an impact.
I could build if this was a vacant lot, I could build as a matter of right a higher and wider house. The house that is there now, nothing is changing on the front except the addition of a dormer, which, by the way, is kicked back. So as to create some undulation in the facade, which some of the board members recognized. So actually, if we were starting out of whole cloth, you could have a house as a matter of right, because we know that you can't mess with the height and the square footage. You could have a house that would be much more significant in that front location. Take a look. I would just ask you on that point to take a look at the
On the point
elevations.
with this application possible, you made a inference in terms in generality. I'm making a response to that by stating that we still have a responsibility in terms of overall impact, especially if there's a new element being added to the front facade of any home. This is point of reference.
Yeah, and you have to view these things in comparison. You could have a much more significant house built in a conforming location at a higher height than is proposed with the taking of the existing house, moving it forward, and the addition of a very small dormer, backed off from the closest part of the front of the house. So I think if you look at the elevations that you have before you, you'd be hard pressed to find that this house moving forward would be more massive than another house that would be permitted as of right. So I would just ask you to look at that.
Thank you. Anything further, Council? Nothing further?
Nope.
Okay. Any public comment on the application? There was, Zach, there was reference to the district as a whole and changes or adjustments, especially as the house is moving forward. In this particular area, which is Herrick, there's no definitive streetscape, and therefore there would be no historic impact.
Well, I think
based
it
on the-
varies. For one thing, it varies from one side of the street to the
To
other.
the other, correct.
I think that's been pointed out. That the houses on the north side of the street tend to be more uniformly close to the street. either through design or accident, I don't know.
Which in itself, does that create a
No.
precedent for a particular streetscape?
No, I don't think so, because the houses on the south side, which arguably would be more relevant as being next door, et cetera, there is some uniformity, but there is no precise uniformity as to setbacks. There's a variety there.
Okay. All right.
And as to flip-flopping, I think that's quite presidential.
Please, let's not talk. Let's not talk.
I confess.
This is my only
I confess.
away from television at this point that's going on. Jeez. Jeff, any comments?
Yes, the house is where it is, whether it's historic or otherwise. As it exists, it's in conformity, within a few feet, but it's conformity. And in my judgment, which is what we're charged with, we're a judgmental board, the current plan,
Hope we're not a judgmental board.
well, we make judgments.
Okay.
You have to make judgments.
But in my judgment, the plan as it currently exists, the design as it currently exists, would create an unacceptable disharmony for me, in my judgment. And I would wish that the applicant consider building structures to accommodate their needs to the rear of the property.
I invite you to come over and look at the rear of the
Oh, I
property.
have done.
Okay,
I
and
have.
when you go over and look at the rear of the property, it's a magnificent sense of place, particularly given the fact that it's probably 100 to 120 feet shallower than these vaunted 3 houses down the street, okay? So what you're talking about is a significant reduction in value the Chryslers have taken. The back, it's beautifully landscaped, there's specimen trees back there, there's a pool. They don't, you know, they have done a wonderful job, and without some significant impact being demonstrated on surrounding neighborhoods, it's patently unfair and would be capricious of you to require them to take over that rear of their house for no reason.
I would argue with the word capricious, and I understand when you put that out, there's a reason you do that. So it's, again, in my judgment, I think the applicant does have options to move.
We're not moving the house.
No, I didn't say move the house.
No, we're
To
not
mo-
moving
to
the
make
house. We're not moving the
structures-
proposed location of the proposed house. The
John,
proposed the
John.
house is proposed at a conforming setback. You have no power to move it back. So if you want to talk to me about how this could be some design change or something, because remember, we're taking an existing house and we're not even taking up the entire volumetric envelope that you could have. We could build a higher house at the same
Right.
minimum setback. So as a matter of right. So I don't know how, but you can't make your decision based upon what in your mind would be a perfect world. You have to make your decisions within the parameters of the law.
So I appreciate you for putting words in my mouth and thoughts in my mind as well. So the board is charged with judgment. There are options, there is space in the rear. I'm only asking the applicant to consider it. The applicant came here several weeks ago.
We've considered it. We're not
John,
doing it.
please let me finish, and then you can talk.
Mm-hmm.
The applicant came here saying that they wanted to create more space for their family. And I'm just saying that there is space in the rear. Whether they choose to use that space or not is their prerogative.
You can ask me to do something if you have the legal power to ask me. If you don't have the legal power to ask me, then my
I have the
clients
legal power
don't.
to
No,
ask
you
you.
don't. You don't have to. You don't have the power to ask me something.
You don't have to do
something
it,
that
I just
you
have
don't
the power to
have
ask.
the power or jurisdiction to require me to do. No, you don't. And you've asked me, and we have no intention of agreeing to any
Asked,
sort of.
answered. Susan,
Thank you.
your comments?
I have no comment.
Christine, comments?
I mean, given that the house is moving forward, I want to take a closer look at the architecture in the front to see if the design of the house, as you're proposing it, needs to be stepped back a little bit so it isn't too overpowering.
Understand, Christina, that I can only deal with what, in all fairness, what that addition is off to the east. The rest of the house is what the house is. But I understand.
Point taken. Appreciate your presentation, appreciate the information you've given us. and appreciate the history lesson on the Southampton Village Code, as you do all the time.
It's important.
However, with that said, this board does have a responsibility overall to review each application independently. And one of the comments that I made prior had to do with generality, meaning if you are moving something forward, I have a responsibility, I have a right, and I have within my jurisdiction to look at the architecture as a whole. And
That's your
even
job.
and I have a right to change my mind about the architecture if it moves forward and has a different impact. With that said, I don't disagree with you that this board has limited, if any, control in terms of pushing forward, eliminating or hindering you from relocating the property. Relocating the structure. That's something that we've moved forward back and forth with the village over trying to define specific code in order for us to know and identify if those are within our jurisdiction. I said before, and I'll say it again, I don't believe it is, and therefore I'll be very cautious about how I move forward in terms of making a decision. However, the architectural I will take a look at.
As
So
you should.
appreciate
I
the
understand.
information.
I don't have any qualms with
I'll
either.
take a look at the information you've given us this evening, and then hopefully at the next meeting we can have a little bit more information.
The only thing, again, that I ask you to remember is that the only thing I can really sort of deal with reasonably, I think, is that dormer addition to the east, because the rest of the house is what it is, and we don't plan any changes
Understood.
on it.
Well, changes are being done to the rear, correct?
Yes, yes,
So
yes, yes.
it's an overall
Of course,
evaluation.
sure, of course.
Thank you.
Yes, that's your purview, the architecture. Clearly.
Thank you.
Thank you.
Zach, anything further?
No.
Any further public comment? You'll give us time to work on that and request an adjournment, correct?
Sure.
Motion to approve applicant's request to adjourn.
Second.
Make a motion that we approve the applicant Jack Chrysler, the 3rd Herrick Road, request to adjourn to our next meeting.
I second the motion.
All in favor?
Aye.
Next application, please.
Oh, next application is Emanon Corp. Emanon East Corp.
Yeah. Proceed.
Good evening, board members, Mr. Studenroth, Mr. Robinson, Ms. Edwards. My name is Monica Navi. I'm here representing Emanon East Corporation at 276 North Main Street. We're here again to request that this board grant a certificate of appropriateness to 276 North Main Street. And I have here on this easel photos of
Bless you.
the front of 276 North Main. I just want to make sure everyone's familiar.
Okay.
Also, turn it around for the camera. So this is how 276 North Main looks. The entry into the village as it is now. We're requesting for the certificate of appropriateness to be able to demolish the existing dwelling and construct a new dwelling pursuant to the plans prepared by William Slight dated December 5th, 2015, which you have in the file. We have today architect Gary Sanders on behalf of Mr. Slight, and I'd also like to submit 5 copies of the same plans that you have, but in a smaller version, just so that you have that.
There was a step prior to us looking at those plans. They still
I
have to
understand,
be-
I just want to get it all in.
Sure.
Last hearing, Unfortunately, Mr. Studenroth, Mr. Robinson missed my presentation. I did submit extensive amount of documents, including the code, including photos of 276 North Main, including a Foursquare report that was done, which pointed out almost 100 Foursquare architectural properties in the village. So I wanted to make sure that Mr. Studenroth and Mr. Robinson were aware of what was in the file. So this board, and again, I understand that we have to discuss the certificate of appropriateness, but I want to make sure that the board knows that they have in their file the plans for the new house that would be built on this lot. Now, my client is planning on building a house that would indeed be compatible with the character of nearby properties as per code section 65-53. I'd like at this point just to show a rendering of what would be there, and then I'd like to focus on the other.
The other actually has to be first. Unfortunately, before we look at, we can take in consideration what will be built as part of the certificate of appropriateness to demolish. But however, there's an evaluation that was done and presented, has not been presented, but it was prepared by our historic consultant with regards to the current structure. And we really need to analyze that, and the recommendation of the board has to be granted whether we are going to proceed and move forward with the certificate of appropriateness, really before we take in consideration the set of plans that you're proposing.
Right.
Go ahead. I'm sorry.
Understood, but because already the plans are in the file,
Correct.
I also wanted to make clear for the record of what we are proposing. And after we discuss the certificate of appropriateness, I'd like to also include what the rendering would look like, and I also have handouts for that.
Very good.
Curtis, I have to say something here, Monica. I think that this is in an inappropriate procedure. This board is not contingently considering the demolition of this house, and I think you're prejudicing your client's case by submitting this. What is going to be built on this property has never been considered by this board as a condition to demolition. And I think that it looks like a bribe to the board that, well, if you demolish this house, what is going to be there isn't so bad, or it's acceptable to the board. That's not the criteria of the code nor the procedure. In other cases, this board has had strong arguments by attorneys to say exactly what you're saying. Well, here's what we'd like to build, and why shouldn't you consider this now? And there's not really been that much of a critical, definitive kind of response to that. But as these are going forward, this is not the right procedure. This is not the right criteria, and this is not the right presentation to the board. How do you justify, and I'm asking you the question, submitting what's going to be built, because this board knows full well, in every case that's come before it, the board is fully aware that this property could be sold tomorrow, that house could be changed by this owner or another owner. So what difference does it make what's going to be on that property? And I think it's a prejudicial issue to an applicant to do this.
Interesting you say that, because I've appeared before this board several times, and particularly with example 4248 Old Town Crossing, 104 Lewis, where we were discussing whether the property should be demolished, and the board was very curious to see the plans that the builder had.
If
and
I
we
could-
submitted, now I'd like to finish, please.
Well,
I had
would
need to
correct
respond
you
before.
as a point of fact, that the other properties that you're referencing were not contributing historical properties in the village.
But if
This
we're-
is.
I have to
Okay.
finish, Mr. Studenroth,
Fine.
please. I understand the properties of 4248 were not in the districts. I know those cases, those properties very well.
Mhm.
As well as at 104 Lewis, I was asked, if we were to demolish it, what would the building look like? So as a courtesy, we did submit plans. And I don't want to get off topic, Mr. Robinson. I will wait until we finish with the demolition, but because last hearing, neither of you were here, I was able to submit several documents, including the plans, and I'd like to just finish out and have a comprehensive record to show what would be there. And I understand we're getting ahead of ourselves, and I'll just stick to the point.
Well, you're right, I wasn't here, I probably would have objected then, and what is your theory, the two wrongs make a right?
No, I'm just,
Well, you
that's
got
something.
him in, but that doesn't mean the board has to further consider it, and that doesn't mean that you're not further prejudicing the circumstances of your applicant by doing this.
It's just based on my experience on what the board has done in the past.
Well, the board, that's not a correct characterization of what this board has done or not
Well,
done.
we submitted-
Every application is unique, every application is different, and I'm simply saying that this is a situation where, having not my presence at the last meeting and getting something in that otherwise might have been objected to is no reason to continue that discussion at a subsequent meeting.
2 hearings ago, the plans were submitted when you were here.
Fine?
So-
And that's a good
I'm just-
point.
I'm
That's a
just
good point
resubmitting
because
what's already been
we
in the
did sort of
record.
let that in, but this is now getting to be overbearing in terms of
I
this
didn't
application.
submit anything new, Mr. Robinson.
I
I'm just-
understand that,
I'm
but you
just
want to continue the
providing them.
conversation on that. That's my point.
No, I'd rather just continue with certificate
Okay,
of
so
Well, let's go back
what we
to the
decided
certificate of
to do
appropriateness.
is to
If I can
analyze.
just finish the certificate of appropriateness
That's
discussion?
where we're heading.
Okay.
So we're gonna have a discussion about the certificate of appropriateness. A report was done by our historic consultant with regards to this property and it as a contributing structure within the historic district. Zach, what is your presentation, please?
I'm not finished yet.
Yeah, we're gonna ask for Zach to continue on
Okay.
moving forward with the presentation.
Okay, well, after a brief description of the existing house and indicating that it is in fact a contributing resource, my recommendation is quite simple. The Bert Jagger House at 276 North Main is a contributing resource in the North Main Street Historic District and a distinct asset to the eclectic mix of historical house styles that make up that district. It's therefore recommended that a certificate of appropriateness to demolish the house be denied and that appropriate preservation of this classic four-square style dwelling be undertaken by the applicant as an alternative to demolition. Pretty simple.
That's your recommendation.
That's my recommendation.
Okay, you have a rebuttal, I'm sure.
Yeah, no one's doubting that this is in a historic district. However, listing a property on the national and state registers by itself does not limit the private uses of the property. In fact, private owners of properties on the national and state registers may alter or demolish their properties without any regulatory constraints, provided they have not accepted federal funds for repair or renovation of the property, or there is no limiting local law. As per the village code, and Mr. Robinson, correct me if I'm wrong, nowhere in the code does it say that just because a house is in a historic district that it is precluded from being demolished. And specifically, I point out, as I also submitted last hearing, under 65-4, certificate of appropriateness, no person shall carry out any exterior alteration, restoration, construction, reconstruction, demolition upon property designated a landmark of property within a historic district, nor shall any person make any material change without first obtaining a certificate of appropriateness from the board. So there is actually a mechanism, a procedure in the code itself that allows for, even though the house is in a historic district, for us to make the application and for you to review that. Now, just the fact that it's a Jagger house does not in itself make it a significant contribution to the character of a landmark or historic district. In 65-5, there's criteria for approving the certificate of appropriateness. And new construction shall be compatible with the character of nearby property. So when you talk about procedure, the criteria for approving what I'm asking, A, in determining whether to approve or disapprove an application, the decision to approve or disapprove shall be based upon the following principles. Number 1, features or properties which make significant contribution to the character of a landmark or historic district shall be altered as little as possible. Being associated with a local prominent family as the Jaggers is just not solely enough a significant contribution. Number 2, this is again part of the board's purview in approving or disapproving our certificate. Any alteration of an existing feature shall be compatible with its historic character. And number 3, which is why we brought up the plans for the new construction, because in this code it says, new construction shall be compatible with the character of nearby properties in the historic district. So how can this board actually determine whether you're going to issue the certificate of appropriateness if you're not even considering what the new construction would be? So in fact, I think the procedure is actually very clear. There's nothing in here that precludes us from demolishing it. And even let's just talk about the certificate of appropriateness. you have to also consider the new construction. It's right here in the code, and I've given out copies of that under 65-5 B3. That's what the code says.
You don't understand the code.
No, I do.
No, you don't.
Okay.
Keep
Explain
the
it to me.
decorum, please.
This-
Civil, please.
I'm
I
doing
know, I
very
know, I know. Just keep it civil, please.
So the fact is, and I think that some people just can't take no for an answer.
Keep it civil, please.
My first question is, does this board really have the proper jurisdiction this evening? Because has the subdivision been granted?
They're still in conversations.
Has-
And again, no, we're looking at this one
has
property.
the
No, excuse me,
subdivision
excuse
been
me.
granted?
We are looking at this one house. You have to focus on this one particular house. I understand
Okay.
it's in a historic district. I understand it's a Foursquare. We submitted a report that says there's
Yeah.
over hundreds of them. They're mail kit houses. There's nothing unique about
Please,
it. No,
please
I
don't
have
get
to finish,
distracted.
and I have to make a clean record.
No, I asked you
okay?
a question.
No, I understand the code, and it's not that I don't take no for an answer.
I
But
didn't
there
say
is
you
something
didn't. I
called
said some people
code.
don't.
And I would ask that Mr. Robinson, as an attorney, point out anywhere in the code where it says that we are precluded from demolishing this house just because it happens to be in a historic district.
Monica, it's not that it's in the historic district, it's a contributing resource in the historic district.
And how so? I mean, that
How so?
burden is not on me.
No,
It's on
Nobody
you.
said it was.
And what makes it
There's
contributing?
no
Because it's
burden. It
Foursquare?
is building structure inventory form number MA-9, which was a survey form that was filled out in 1979. That was 30 years ago. And it is on the basis of those survey forms, whether the new owner wants to appreciate this reality or not, it's a matter of choice to purchase property in the historic district or not. That's not an issue this evening. The point is, this particular house, which happens to enjoy a rather large piece of property, which I understand is being submitted for subdivision, but perhaps has not as yet been granted. So what is the property that this contributing building sits on? What are its meets and bounds? What is the survey that's been submitted that we can see where it is situated on its piece of property? Okay? And I think that's material tonight, because if it is determined that this particular house, because it's a contributing element in the North Main Street Historic District, can't be demolished, that's not just the house. The house is the property that it sits on, which is what is listed as contributing. So that impacts the entire project, I should think, more than just the parcel which might ultimately be that which the house is sitting on, which has yet to be granted. So I think there's considerable ambiguity about what's being applied for. You brought up the Jaggers. I'm sure that was a fine family. There were many early founding and settling families in this village. Whether this is a Jagger house or a White house or a Smith house matters not. It's simply a matter of record. That's a name that occurs and is identified on early maps. This board doesn't concern itself with the Jagger houses instead of the White houses. It's a building that was placed on the survey, which later became the district. You're confusing something.
No, I'm not confusing it. And I
I'm
want
going to
Mr.
explain-
Robinson to explain the
I'm going
code
to
then.
explain this for the benefit
No,
of
I
anyone
understand.
who's interested.
Your report
Please
said
do
it's-
not interrupt me.
No, you've interrupted me many times, Mr.
Decorum,
I'm
Heisman.
about
please
to make a
decorum.
statement.
Please decorum. Listen.
It's important
Mr.
to
Heisman.
realize that this house is listed on the National Register because it is considered a contributing element in a historic district that's listed on the National Register. It is not individually listed on the National Register. The point of jurisdiction is not the National Register, it's the local building department, which is charged with the review of applications for properties which are located in the village. The listing of National Register has nothing to do with it, okay? So I just wanted to clear that up for you.
Yes.
I understand. Saying that it's a contributing and a Foursquare is not enough to preclude our request to demolish this particular property.
Monica,
And
we
Mr.
understand-
Robinson.
Yeah, we
in
understand that's what your
65
request is.
In 65, I'm requesting for you to approve our certificate of appropriateness.
We understand that.
Okay, and under, if you said that there was several, that I wasn't going around the right procedural way, then
No, I
why
said,
in your
I said by
code?
submitting the proposal for
Well, I
what
have
might
to
be
because this is
built.
part of the criteria for approving the certificate, and it's in the
No,
code.
No, it's not.
No, it's not.
So 65-5, B3, it says, the board's decision to approve or to disapprove shall be based upon the following principles. And again, it lists them, and under number 3, it says, new construction shall be compatible with the
But
character
there
of
can't
nearby
be any
properties.
new construction until the present construction is no longer there.
Well, what if it was a vacant lot?
Then it would be new construction.
Then it'll be different.
And there wouldn't be a
Well,
contributing, and it wouldn't be a
It doesn't
contributing.
say that in the
and-
code. And 2 meetings ago, we did submit the plans, so I wanted to
I
ensure
understand
that you have
We
that.
understand that. Okay, we're at a standstill here, and I'll tell you my view, because I think you and I being the longest members of this board, unfortunately, we have set a precedent in the past. And I'll just let you know what that precedent is, and we'll move forward. If a contributing structure within the historic district hasn't been refuted, there's been no evidence of anything removing that from a registry that currently exists, hasn't been altered in a way that now eliminates its historical nature, hasn't been taken out of any district, has not been removed, it's still a contributing structure standing within the historic district. This board does not and has not approved a certificate of appropriateness to demolish. What we've asked is if you can show evidence of hardship, which is a different application altogether.
And that's only if you deny the certificate of appropriateness. We're not even there yet. I mean, we did submit a
We're
report
close.
from an engineer. No,
So-
that's fine. I mean, I just want you to know that I
Yeah,
understand,
I understand
the
that,
procedure.
but what I'm saying is that this is what we have done on application after application application. Unless you're demonstrating that the house that you're proposing has either A, no longer has any historical relevance, significance at all, or has been removed from the National Registry. And is there any other criteria that you can think of other than those two, which are the main two that would remove it from its being a contributing structure within the historic district? The process is denial, and then you as an applicant have the discretion to come back before this board for hardship
And make your case.
and make a case that it would be financially feasible for you to move forward with it currently existing or doing any type of alteration. I want you to know that the standards of that are reasonable rate of return or reasonable return, which is relevant in itself because you would have to show what your hardship case would be, the cost, an engineer's report demonstrating that it is so out of compliance that it's inhabitable and it can't be repaired. Is there anything that
No, that covers
So
it.
where does 65-5 B3 come into play when it says new construction shall be compatible with the character of nearby properties? This is something
If
that
you're
you
if we
as
were
a
to tear it
board.
down?
After you've torn it down.
After
Yeah.
we
Where
On
does
a
that
vacant
say that?
lot.
You're taking it out of context.
No, I'm not. I'm reading it word for word. And
That's
I
Plus,
know.
we
there's
have the-
nothing
But
in this
it's
code
in the
that
context
says.
of a whole
Support your
paragraph, but I
application.
think
Okay,
it's not worth arguing.
I'm just
No,
demonstrating to you
it's
what
not
we've
about
done.
arguing. I'm making a
This-
record, and I've already submitted everything, and I would like to submit what would be there, which is already in the
Well, we have
file.
the plan, but you don't make a presentation on it until you've got your permission to tear the house down.
I'm not making a presentation. I'm just putting it to the file.
So we'll put the plan in the file.
Okay.
You said it's already there, is it not?
Right, and I also wanted to add what it would look like, what the new construction would look like,
I thought what was previously
the
submitted?
plans.
Well, then
this
they
is the
should be good
rendering.
enough. They should be good enough.
We don't need that.
Well, I think it's important to put it at least
Well,
to show what the
I'm
new
gonna
construction
recommend that
is.
these documents not be accepted on the issues that I discussed with further. If
Okay.
it was a mistake or the board gave some leniency to let them be submitted previously, that's one issue. But I think the issue here is what are the merits of this house as to why it should itself be demolished without looking to say, oh, well, there's gonna be some other better, different looking house in its place. The
There's
issue
no-
is, what are the merits? What is the presentation to the board of a prima facie case as to why this should be demolished?
Other than saying it's a Foursquare and it's a Jagger home, that's not enough. to
Okay.
say that it cannot be demolished.
Alright.
It doesn't possess any special historic character. It lacks identity with a historic personage or attribution to a noted designer, and lacks unique status in the neighborhood. What Mr. Studenroth has submitted, there's no mention of that at all. By
I don't
saying
need
it's a
to make a mention.
foursquare,
It's already on the survey. It's already a contributing. It already met that test.
but you can't just
So
say
if
it's
you want to
contributing, so it should
read-
not be demolished.
There's a wonderful document in the building department, and it is the application to the National Register for the district. It's only about 90 pages long. I suggest you read it, because in it, it makes a case for the variety of houses, primarily residential, et cetera, in the district. And there you have it. So read it. And it talks about all the different building types, et cetera. So
To say that it's contributing is not enough to deny certificate of appropriateness?
not for you, apparently, but it's
No,
It's
come
the
on, come on.
code.
No,
it is
we-
the code.
We have tools that we use as a board.
Well,
So
I'd like to just look at this house, and I have architect Gary Sanders here that can talk about,
we understand that, but we have a standard, we have a direction, and we have had.
but I have to
many
also
appli-
make the record for my client, Mr. Highsmith, and
Okay,
if I have an
understood.
architect here that's going to address the actual structure
And we
as it
have counsel who
stands.
said that they need further information with
No,
regards to
that
what.
we can hear his.
No,
wanna-
this is
you wanna
about the
mind it?
house.
Sure.
He's not talking about the new construction, it's about how it stands now.
Yeah.
I mean, we have that right, and I'd like to put that into the
Counsel,
record.
Please
counsel
do.
saying yes, then
Please
I-
do.
Okay.
No, that wasn't the reason why, but.
Hi, my name is Gary Sanders. I'm with WH Light Architect. We're the architects for the lots, and I'd like to talk to you about the existing house as it stands now on the lot.
Very good.
As you can see, there's really no architectural significance besides it of the shape of a foursquare that this house has. The shingles have been changed over time, but they're not the original shingles. The house has an asphalt roof.
Okay.
The porch has been filled in on the north side. The porch would have went all the way across and was open at one point. Okay. The house has the original wiring to the house. Is very, is,
Zach, please. Come on, it goes both ways. Come on.
well, what,
Behave,
the point,
behave.
the point I'm,
Please.
the point I'm trying to
Totally
make.
inappropriate,
Yeah.
and,
I just chastised.
well, I
him.
appreciate that.
The
Yeah.
point I was trying to make is
apologies.
the house
Once
needs a
next-
tremendous amount of work
Exactly.
to restore it, okay? The windows are single pane, have, storm panels over
Yes,
them.
present his- he has to
Um,
present his case. Hold on a
needs to be-
second, because we're having a lot of chitter chatter and board members. The applicant has the right to present, and he's presenting the current house. He's giving testimony and information on the existence of the current
Right.
house. Allow him to do so, please.
Right.
Okay?
So the house would, to bring it up to today's standards, would really need to be brought down to the studs and redone from the inside out. So once that happens, what is really left of the existing structure, besides the shape of a foursquare? And that's where our client would like to put something in its place because of the amount of money that would be
Is
needed.
that the hardship? Different application. I'll discuss that
Okay.
when we finish, but different
But-
application.
To bring this up to a condition where it would be inhabitable for today's living family.
Okay. What you're talking about is a financial hardship.
Yes, I understand
It's an
that.
entirely different application, and
Okay.
in order for that to happen, this application has to be not denied.
I understand
You
that.
would have to reapply for a certificate of appropriateness using the hardship.
I understand that. I'm just talking about the condition of the
Understood,
existing
but
house.
when you're making reference to tearing it down to the studs and that there would be a financial burden or hardship or
Yes.
the cost of, that's a hardship. They can't be used in determining the application for this evening.
Okay, that's fine.
Okay.
Okay. All right, thank you.
Anything else, Zach? Is there anything else?
Well, yeah, briefly, I just wanted to point out that houses architecture in general is vulnerable because it's exposed to the elements. Unlike other art forms, it can be taken inside and protected and kept heated and dry. So having new wall shingles, roof shingles, these are sacrificial, you're an architect. So these are sacrificial elements in a house of any real particular historical age. I would venture to guess that virtually every contributing building, unless some that have been sadly neglected for the last 80 years, have received new roof coverings, have received new wall coverings. So I'd only point out that it's expected to see those elements, and perhaps it's been done well, perhaps it's not been done well, but those aspects, which are considerable, that's the skin of the building, so that's a lot of what you see. But those are elements that we would expect to have been renewed over the years, otherwise the darn thing would probably be falling apart by now. So I wouldn't worry about that so much as what we would call character defining elements. The massing of the house, let's not dismiss the old Foursquare as something we don't care about, because obviously, as you've demonstrated wonderfully, we have a fair number of them in the village, and they kind of define the character of the village in that period. And elements related to that are the way the fenestration is handled, where the columns and the very fact that there's a porch. There are other additions, out sort of extensions, etc. They're all original. As I recall, it's on its original foundation. So, I mean, all of that architectural evidence gets weighed when we're looking at, is this building, does it retain a certain amount of integrity? And in my estimation, I wouldn't have made a recommendation in February that another approach to the building, that being to preserve, et cetera, was feasible or viable if I didn't feel that the house retained a certain considerable amount of integrity. So that's what the intention of it was. Just my thoughts.
And because you seemed surprised at what he was pointing out, I don't know if you saw it in the file or if you looked at it at all. Here's what the architect pointed as to the property and structural integrity, which is obviously lacking. So I'd like you to have that.
Well, I would only say that's not at all obvious, but I'm happy to look at it.
Well, because you haven't looked at the file.
Is that a report for the whole board, Monica?
That's already been submitted,
It's in the
copies,
file?
yeah.
It's in file.
Thank you.
Thank you. Board members, do you have any comments? Christine,
Pardon?
do you have any comments?
No.
Susan? Jeff?
I do, in as much as reflecting what Zach is saying, is that Foursquare is part of the character of Southampton, and unfortunately it's a dying breed, and I would wish that in considering the subdivision that you're going to do, that you would perhaps consider the inclusion of that as a preserved house. And I think this house is worthy of preservation, so I would prefer that it not be demolished.
Based on what? Just because it's a Foursquare
Ba-
that it's preserved?
Yes, because
That's the
because of
only reason.
Monica, because of exactly what I said. It defines the character, and what Zach was saying. It defines the character of the village. We're a preservation board, and that's an obligation that we have. So that's my judgment. So that's
Right, and you also, the word preservation is brought up constantly, and I understand that you're a board of preservation. That also means preserving, not necessarily just because the house is over 100 years old. I mean, you also have an obligation to preserve the character, the quality of the neighborhood. You don't want to see a neighborhood, and particularly as you drive into your village, looking like this. So if you want to preserve, think about
and
that.
what I said, and what I would ask that you and Michael consider is the possibility of including preservation as part of your subdivision.
Which we have and we
the-
would if you let us
understand.
get
Preservation-
So we,
Right.
so we know
preservation-
we're talking about preservation is part of the application, not subdivision. Subdivision is a separate
Right,
process.
I understand. Preservation of
If we
this
could
house.
show you the new construction, we would show you that we are preserving the character of the neighborhood.
Right, but you're not preserving this house, and that's the only thing I'm talking about.
'cause
Preserving
we're
this
asking to
house,
demolish
and
it,
I'd like
obviously,
you
right.
to consider preserving this house
Absolutely.
in whatever you might do going forward. Thank you.
Any public comment on the application?
Michael White, Southampton. I don't know, I've been before the planning board, and I brought this to them. They love the idea of having a picket fence across it. They could care less about that house. It's dilapidated. I mean, I've watched this board, one mansion after the other on the ocean, historic, torn down. All right? You just tore down the boathouse. You just tore down, you just gave approvals for part of the Waldorf estate to be torn down, one of the carriage houses, or two of them. Okay? No, nothing from Zach. He doesn't say a word when that's happening on Gin Lane. But this piece of junk somehow is worth keeping at the entrance of the village. I've been before the trustees. I told them what I was doing. They loved it. I showed them renderings. They loved it. They want the entrance to the village cleaned up. To keep this is ridiculous. It's fallen apart. Anyone, I mean, Jeff, you make a comment about the house. You've never been in it, have you?
Yes, I have.
When?
Early this afternoon, I was running
You
around
went
the
in the
property.
house?
Yep, I knocked on the door, yeah. I went, not actually in it, I went around the property, yeah.
And you think it's in good shape?
No, I said it's worthy of being restored. But again, that's another issue.
But you
I
have
would
to
like-
understand, listen, I can't go before this board with a hardship, because it's not a hardship, okay? I can never prove it's a hardship.
You said that on record?
I'm saying that on record.
Yeah.
I can't, and I'm not gonna do it, because I can't prove it. I'm not gonna lie to you. But are we gonna get technical, and you're gonna, you know I'm gonna leave that house like that. I mean, you know that I'm not gonna do a thing to it. And that's what you want? That's what, you think
Well,
that you're doing the right thing as an architectural
You're
review
not
board?
performing any work to the house or doing any alterations to the house. As sad as it may be, we're only here determining what we should do in terms of the certificate of appropriateness.
No, that's not your job.
That is so
That
arduous.
is not your,
I've
you're
known-
the architectural review
And
board.
historic preservation.
Okay.
There's a continuing
Your
label
job-
to what it is that we are.
Your job is the aesthetics, and you keep saying
And
you're an aesthetic.
historic preservation.
Are you
There's
an
an
aesthetic
continuing.
board?
historic
excuse
preservation.
Me, this, with the historic district, the board functions as an historic preservation board.
Okay, but is it aesthetically worth, and you know that I've made it clear what kind of houses I want to build. I want to build white farmhouses, like the house that you talk about that's on Main Street that was renovated. That's what I agreed to do, and that's what I will do. And I will put the white picket fences from the bed and breakfast
No,
all
this-
the way down.
this
And
is
you
a
want
di-
me to put
Michael, this
in
is a difficult thing that this board has to do.
I know-
And
I know
express
this.
to you why. Because we literally have to take one hat off, which is the aesthetic, and put another hat on, which is the preservation, which has to go first. And if we can preserve the current architecture of homes that not just are in the historic district, but have been identified as a contributing structure, we have to go out of our way to make sure that they are preserved.
But that was flawed when they did that. That
You
was
have not,
1979.
but you have not determined any type of flaw
I
in the
don't have
process.
to. It's on your.
No, it's not. You present before us. Our responsibility is to read, see, and analyze the information you get before this board to determine and answer a solution.
Arbitrarily.
If you don't give me, there's no arbitrary in that. It would be arbitrary for us to make an outside review outside of the jurisdiction of our precedent. Unfortunately, right now, you have not presented anything before this board. You haven't presented
This
anything
board
before
doesn't
this
make
board.
precedent. This isn't a board that makes laws.
We didn't say making law.
You just
I didn't
said you
say-
make precedent. You can't make precedent. The law is the law here. You can't make precedent of what you think you should do and what. There's
We're
a
not
law
making
here.
what we think we're following the procedures of this board.
In
And
1979, all right, or whenever it was, they just went and took a whole historic district and said everything in it is historic, is contributing. Basically, that's what they did.
I'm sure that Zach would disagree with that. And again,
would, but I'm trying to-
Michael, at the end of the day, this board has to review and analyze what you present before us to make and render a decision.
Okay.
We don't have information that will determine that this particular structure is no longer a contributing structure within the historic district.
But-
if you can present that before us, we have a different decision.
What-
Go ahead.
I agree. I'm sorry. I know that it's a hard decision, and I know you want to keep the precedent going. But for the betterment of the entrance of the village, isn't it worth doing, this rather than this? I mean, this is crazy. Like, what are we arguing about? Why are we arguing about something that's falling apart, that's garbage, that's a rental house, it's, the heating system's gone, the electric's gone. I mean, even if I did that and I didn't show a hardship and I had to rebuild this, what am I gonna tear it to the studs? What are the studs of a house? I mean, that makes a house historic, is the wood studs? I mean, it's not a post and beam
Well,
house.
there should be a process of preservation, and that's what we're.
Some of
working
us
with.
make a living looking at studs.
I bet.
Whoa, whoa, let's just move forward. 'Cause that is-
And a very
This is
successful
going
one.
someplace, let's please. Oh, God.
But you gotta give Michael credit for that.
Mike, ultimately, we have a difficult decision, and at the end of the day, we still have to analyze what you've given us. Telling us something's torn down and it's not worth salvaging, it's not worth preserving, it's not giving us the facts that we need to move forward.
Well, the problem is I don't have a financial burden if I don't tear it down. I mean,
That's
I'm
a
not,
process.
I'm not going to meet that process.
Okay.
So
So what you have now is to determine this structure is no longer a contributing structure in the historic district, as classified in a form that's been given to not only the building department, but I believe the state, correct?
but it doesn't sound like you're going to waiver off of that.
You haven't given me anything to waiver off of that.
I mean,
Well, the burden is on you, not
No, the
us.
burden is not on us.
No.
The burden is on you to present an application before us.
And in the past too, we've submitted reports on Foursquare. We submitted, under the code, there are criteria for approving or not approving certificate of appropriateness. I have failed to see how you have pointed out that this house is making a significant historic contribution to the character of this neighborhood.
The burden is not on me as the consultant or this board to prove or to imagine why in 1979, which was a couple of years ago, why this house was surveyed and why it was included. It's surveyed, it's described, the district as a whole is described, and various contributing elements are characterized and why they're considered contributing. You keep bringing up other projects which were of buildings that were not in the historic
Well, in
district,
this code
and
it
that
says-
is an entirely separate matter.
I understand if a property is designated a landmark or a property within a historic district, there's a procedure, and we are requesting for that certificate of appropriateness, and
That's what
there's
you're going to be doing right
standards.
now. You said that a few times. That's what this proceeding is the process
But a board of
this-
preservation doesn't mean just because it happens to be in a historic district that it should be preserved. I mean, we
Monica,
have to get
it's not
beyond
that
that.
it's in the historic district, it's a contributing
And how
resource
so?
that has a very
Because it's a
elevated
Foursquare?
status.
No,
Because it's
For
a Jagger
whatever
house?
reasons,
Or-
Zach.
Sorry.
For whatever reasons, the criteria established in 1979-77 survey, it's now got this status.
So then
and it's a-
why is there a mechanism where it says criteria for approval of certificate of appropriateness?
So you- but
Where
you're-
does it preclude that we cannot request for demolition
You
of a house
can
in a
request a
historic?
permit for demolition. That's exactly what you're here for. This gentleman has testified on behalf of that. And now it's up for this board to make a
Okay.
determination whether or not the applicant has prevailed upon its prima facie case. We had a situation with a house over on Meadow Lane 2 years ago. The house was extensively reviewed by engineers. They did excavations next to the foundation, which were locust posts. Part of the house had cavitated 6 inches from the floor level. And with that thorough review, it was established that that house was beyond any reasonable chance of rehabilitation, which the applicant was trying to accomplish. And this board granted a certificate of appropriate to demolish. And like that, your applicant is, you're here tonight to present the case to this board why this house should be demolished.
No, I understand why
And
I'm
the
here. I'm
case,
just,
I mean, so the question
you know, I
now is.
practiced law in Manhattan, appeared before appellate courts,
Yeah,
and I've
sure.
never, in my 12 years, seen such lack of decorum and professionalism.
We're
that it's
sorry for that.
reprehensible.
We're sorry.
I'm sorry for that too. I
So
tried to,
at this
I tried
point,
to
I'm
keep you-
requesting an adjournment, but it really is shameful.
Okay, it looks like your client is saying something different.
I really don't think that your guys are gonna move past this, and I'd like 1 minute to talk to Monica, because I think what I'm gonna do is I'm gonna ask for a decision, and I just find it hard to believe I'm gonna go with an Article 78 and show this piece of garbage to a judge, and he's gonna go, this is historic. I mean, this is getting out of line. I mean, he's dictating the meetings, you know,
I
it's,
don't think he's.
I think he
dictating
is.
it.
I mean,
He's hired to be our
all
historic
right, but,
consultant.
you know, we have the concert house, that's okay to tear down.
We turned that down, by the way.
Well, but he didn't see, he didn't
We
know,
turned
he
that
didn't even
down.
know about it, it wasn't on the register. It's just a bunch of garbage that's going on. The trustees love the idea, all right? They love the idea of fixing the entrance. But he thinks that I should leave it there. So I'll leave it there. I mean, that's probably one of the biggest single complaints of houses in the village, is that piece of property. Between the oil tanks, which I'm trying to block, and this house. But let's keep it, because you guys are the aesthetic board.
No,
Nope.
Michael, they're the historic board.
I get it, but they're
You
also...
don't get it because you keep saying
Because
the
they're
wrong
also in charge of the aesthetic.
characterizations.
Okay, so what you're telling me is that if it's for the betterment of the community, you'll just...
No,
You'll-
Michael, there are historic districts
Okay, well,
set up in the village.
Can I have one?
Can I finish?
Do we?
You finished last time, and you told me about that when I filed my Article 78 on Woolley Street, that I had no right, that this board had a right to put my house wherever they did. And we're gonna find out in a week that they didn't. And now we're gonna go...
That is simply not
Oh,
true,
that is
nor is it
true.
a representation of the actual events.
That is a representation, and you know it is.
No,
And now,
Michael.
I want 1 minute to talk to Monica, and I want to see what I'm going to do, because I'm not going to do this. I'm not coming here 10 times again. I came here 4 times already. We started the project off backwards.
Well, that's, okay, I'm glad you mentioned that. The initial application that came before us was for vacant land.
Nope, it says demolition on it. Read it.
The initial
It's on the
application
orange
was
piece of
not
paper. It says
demolition.
demolition. I went to the building department. They said
After.
you misread it.
No, that's not,
Okay.
that's not accurate. That's
It is
not
accurate.
Because,
It's in the file.
well, that's not accurate. The first initial application that came here, because you didn't even realize it, was for vacant land.
No, it wasn't.
And you were under the subdivision process and didn't recognize that this particular application was on the vacant land, not on the vacant land site, but it's on the site that had the structure on it. Neither here or there. However, yes, you've been here a few times. We've come to a point now, crossroads on what you wish us to do. Are you looking to spend some time to build build the proper application to justify having this be determined a non-contributing structure within the historic district? Or are you asking this board to make a decision?
Can I have 30 seconds?
Take your 30 seconds.
Can I hold you up then for one while I'm at it, while Casey?
Sure.
I'm holding on to it.